Thank you very much, Mr. Chairman and members of the committee. I'm DeBare. I'm the Executive Director of the Rhode Island Coalition Against Domestic Violence. I appreciate the opportunity to speak on behalf of the bills tonight. The coalition, our 6 member agencies, and our Survivors Task Force are here. We represent over 9,000 victims of domestic violence that are served every single year. I appreciate the passion and support that all of you and many of you have expressed, and many of the people who have spoken this evening have already expressed about concern for the scourge of domestic violence in our society. I want to restrict my comments primarily this evening to our support for Bill 2730, Senator Goodwin's bill. To address your point, Senator Lombardi, I believe that this is the common... I'm sorry.
No, my phone is ringing.
I'll hold my point to get back till you get back. I believe this is the bill that is the common sense gun bill that has come about after years of working with people from diverse opinions and perspectives. Like Joey, we have worked on these bills to address the issues of guns, firearms, and domestic violence for many years. We sat down with people from different perspectives. As a matter of fact, at the end of the 2014 legislative session, the language that's in 2730 was suggested in part from the Second Amendment Coalition. We at the Rhode Island Coalition Against Domestic Violence have compromised significantly since the first time I came here to testify before you about guns and domestic violence. 2730 does not include the petty misdemeanors. It does not include disorderly conduct. It takes serious crimes of domestic violence, people who have committed and been convicted of domestic violence misdemeanors, and says that they are subject to having to give up their firearms. It's not about an allegation. These are people who have been convicted of misdemeanors. And I need to stress that it's not the petty misdemeanors. That's what people are getting confused, it seems, when we talk about it's not those less serious crimes. The main reason that we are so passionate about this particular bill is that I know that in your job as legislators and my job as an advocate, we are doing what we can to protect all Rhode Islanders, not just some classifications of Rhode Islanders. The federal law has a loophole in the sense that it only protects victims of domestic violence who are married. In Rhode Island, our Domestic Violence Prevention Act protects all victims of domestic violence, whether they're married or whether they're dating, whether they're in homosexual relationships or heterosexual relationships. All victims of domestic violence deserve the same protection. So it's really a simple matter of fairness that we take the language that was in the federal law protecting victims of domestic violence who are married and make sure that it's included, the firearms protections are included the way Rhode Island's laws have been crafted.
What did I do wrong about that?
You didn't do anything wrong.
Okay.
But you raised an important point that I was saying that I believe that Senator Goodwin's bill 2730 is the common sense version of the compromise language that has come out of sitting down with the Second Amendment Coalition, the Public Defender's Office, the Attorney General's Department, from survivors themselves. We worked in committees. We worked in conversations to craft language that we felt was a compromise for all perspectives.
And I apologize. I took notes on every bill that was brought before us. And if the Second Amendment Coalition commented on this bill, I must have missed it because I don't have any written notes on this. Today, what was there? Can you tell me what you heard?
I didn't jot down what they said about that.
Okay.
I don't know,
Okay.
Rachel, did you have?
Okay.
Yeah. Yeah.
I believe in the 2014 section, the part that says that this won't apply to any bill that was expunged or pardoned. That's directly out of the federal statute. We were reading it to apply any extra expungement processes that aren't already in the expungement laws in Rhode Island. So if that needed to be clarified, I think that could be easily cleared up, because that seems to be the main concern with that bill.
Actually, I think that'd be
the last numbers on that, though, that you said were...
No, we're not going to start having people talking different.
You're right.
I'm sorry.
If Mr. Bear doesn't know, well, certainly someone can look at the tape and see what he said later. You can proceed.
Thank you. That's okay. So our intention was, as Rachel was saying, it is not to have the gun prohibition extend beyond the length of time after an offense is expunged. That's the way the federal law has been crafted and works, and we could certainly make the Rhode Island law follow in the same way.
Senator Conley.
Thank you, Mr. Chairman. Deb, thank you for clarifying what I think is pretty explicit language. And while we all want to be sure with legislation, I think there are occasions when we can overthink things, overcomplicate things. When you look at those, the specific changes in the bill, beginning with line 5, what you have said is abundantly clear. What you have told us the meaning of this is abundantly clear from those few words, that is, it requires a conviction of an offense punishable as a misdemeanor offense under 1229-2. And as you have pointed out to us, despite what other representations have been made, that is not for the petty misdemeanors. Those are for the assaults. Those are for the serious domestic violence misdemeanors. Secondly, if that isn't clear enough, we only need to look to line 12. Line 12 tells us that offense is punishable as a petty misdemeanor under 1229-2 shall not be construed as an offense punishable as a misdemeanor offense under 1229-2. It couldn't be clearer. Although I'm not a fan of redundancy in legislative acts, there are those occasions when perhaps clarity is served by a certain amount of redundancy, and this may be one of those occasions. But it certainly removes any ambiguity about that issue. Then we look at the next paragraph. Let's look at lines 14 through 18 to see if there is an ambiguity about expungement and what it really means in the context of this statute. It says that a person shall not be considered to have been convicted of an offense. Pretty clear language. You are not convicted of an offense. Couldn't say it any clearer than that. If the conviction has been expunged or set aside, if it is expunged, you are not convicted of an offense. I don't know what other words there are in the English language that make that any clearer. And I think additional language or different language would only create ambiguity where no ambiguity exists. Then it goes on to say, after set aside, or as an offense for which the person has been pardoned or has had their civil rights restored, unless the pardon, expungement, or restoration of civil rights expressly provides that the person may not purchase, own, carry, transport, or have in their possession any firearm, which, as you pointed out to us, we look to the federal law to give us guidance on that construction there. But it couldn't be clearer. You know, there's a certain beauty and clarity about succinctness. And for all those involved in the discussion, I think that we ought to look at the plain meaning of the English words in the statute and give them the common sense meaning that we know they all have. We don't need to look to other areas of the law. We don't need to look to how expungement is carried out. We don't need to look at what the rules are for expungement. It doesn't matter. This simply says if it's expunged, it's over. So Maybe my frustration came out, and I apologize for that. But sometimes, language is a beautiful thing. You just have to look at it and appreciate it.
Thank you. And I do want to say I appreciate that. The clarity in that language has come about through many years of reworking this legislation year and again, which is why my frustration is that I feel we're back here this year with the version that addresses all those prior concerns. I have one other point I wanted to just put on the table about why this is such a good common sense piece of legislation. You may hear from others that will say, oh, misdemeanors are not as serious as the felonies. We don't want to include the misdemeanor domestic violences. But we know now, so much more than we did 20 years ago, about the dangerousness and the lethality of the misdemeanors that are charged under the Domestic Violence Act. So, for example, if someone says to you, oh, violating a protective order, it's just a misdemeanor. Violating a protective order under the domestic violence protection orders has been shown through research it is one of the highest lethality risk factors. We are trying to prevent homicides. We've been before you talking about prevention. We believe that this firearms provision addressing the misdemeanors that are covered in the Rhode Island Domestic Violence Prevention Act are a serious step forward to helping to protect all Rhode Islanders.
Senator Lombardi.
I think Senator Conley hit it right on the head, that I think that this is perhaps the pie in the sky, and I thank you, Deb, for illuminating it for me a little bit, because we've got, I think there are 15 bills that we've had to consider tonight, and in preparing for them, we read all 15, and sometimes things get lost, but I think this is the precise bill that should put the three interested parties, so to speak, along with the legislature, in a room, and I now that you remind me, Rachel, that I think the only issue I heard the Second Amendment Coalition say about this bill is the line 16, unless the pardon, expungement, or restoration of civil rights expressly provides that the person may not purchase, carry, or own. And it was something about forum shopping. I thought that's what I had heard. Something about forum shopping because judges change or something like that. Well, but that's, other than that, this is precisely, I hate to use the phrase starting point. I think we're halfway there. And I think that this is the bill that puts us in the room, folks. I really do.
Senator Conley.
Thank you, Mr. Chairman. You're right. There was a discussion about forum shopping when it came to that language. But let's think about this for a minute. We're going to forum shop for the judge that will restore. Let me just find the language. We're going to forum shop for the judge, which when the pardon of civil rights has been restored, we're going to look for the judge that says the pardon, expungement, and restoration expressly provides that the person may not purchase, own, carry, transport, or have in their possession any firearm. We're going to look for the judge that, under those circumstances, under a pardon, civil rights restoration, or expungement, is going to be the judge that will tag on to that pardon, will tag on to that restoration of civil rights, or will tag on to that expungement, the caveat that it doesn't come with a gun. We're going to look for that judge. We do a pretty good job of screening the judges when they come before us. I don't think we've seen that judge yet. I don't think that judge is going to come before us, and I don't think we're going to put a black robe on that person.
Just for the record, I did not accept nor endorse the forum shopping aspect of it. And to the extent that Senator Conley implied that I did, I take strong objection to that.
Senator Nesselbush.
Thank you, Mr. Chairman. Thank you. I want to follow up on the frustration factor that Senator Lombardi, Senator Metz, and other senators in the room, I think, are showing here. We have seen over and over, I've been here 6 years, and we've sat here hours and hours and hours every night, every year that we have the gun bills, and I think you're seeing an appetite like we need to get something done. The last I heard, the last I read, over 50 women had been victims of domestic violence homicides since about 2006. And so my question to the Second Amendment Coalition is, how many women are going to have, how many people, are going to have to lose their lives before we get some agreement that can move the needle on this issue? And I, for one, am becoming increasingly impatient every single year, and I agree. I think this is the bill that people go into a room and you come out with something that everybody agrees will move the needle forward, because just saying that we are, I forget the word that Joey used, was a non-starter. Well, I don't know. Get some gasoline, man. We got to start something up, because we on this committee, as you hear over and over each senator saying, we're sick and tired of listening to the testimony every year and making no progress. And I think I agree with some of my colleagues who have spoken that this is the bill that we seem to be the closest. So, I, for one, am in favor of those various groups going into the room and knowing that if you don't come out with a solution, there are several members of this committee who seem willing to go in and make the decisions about what's going to remain in that legislation. And if you all can agree, I agree with what Senator Lombardi says, that the chairman here is incredibly gracious at listening to everybody and inviting comments and trying to get as much consensus as there can be. But ladies and gentlemen, women and men in this state are losing their lives while we wait around for this process to happen. And again, I, for one, add my voice to the frustrated voice.
Thank you, Mr. Chairman. Joey, do you know comparatively from other jurisdictions, because it's an Attorney General bill, and maybe Deb can weigh in on it, what other states prohibit people from possessing firearms when they're convicted of misdemeanor offenses? Just, I'm not looking for an absolute number, but just comparatively, give me some perspective.
15 states in the District of Columbia, Senator.
15 in the District of Columbia. I will add to that when we talked about that prior bill, Deb, this was one of the points that was fleshed out and talked about in pretty much in a uniformity of agreement. And I don't think you'd get too many Second Amendment people who would, or maybe even one who would come forth and say that somebody convicted of domestic violence, even for a misdemeanor offense, shouldn't have limitations put upon their abilities to own a firearm. And I know from, we joke about it, but I actively prosecute for 3 towns. So, and I was in court today with domestic violence cases. And so I see it. And I work with your advocates and on a weekly basis in a high volume of cases. And you run from the minor stuff, which is the petty misdemeanors, which shouldn't be in this bill. And you've done a carve out for that. And then you've got the more egregious stuff. And it's not, just so everybody's clear, you don't go from having no record to getting convicted of domestic violence. That just doesn't happen. The people getting convicted of domestic violence have been in the system either multiple times or they have very egregious fact patterns. I want to be clear about that. You come into the system with no record and you start with a thing for a misdemeanor called a filing. Filing means that it stays on a shelf for a year, you don't get in any trouble, it goes away. For domestic violence, it stays 3 years before it's capable of being expunged, so that we know about the crime, just like DUI laws, they last a little longer because people lose their lives from these bills. Then the next step up is probation. You don't just get probation. You get probation if the facts are a little bit more egregious or if you've already had a bite at the apple, right? Still not a conviction. Still not a conviction. And then the step after that is a suspended sentence. A suspended sentence is an actual imposition of jail time, 1 year at the ACI, suspend it. And then in Rhode Island, we add probation to it so that it can monitor certain requirements, like the domestic violence classes and batterers intervention classes. And then you've got actual jail time. So filing, probation, suspended sentence with probation, and that is a conviction, and then jail time. And of course, when you have a monetary fine imposed, even for a minor offense, that can be a conviction. That's something that you'd have to be mindful of in the system. Judges would have to be mindful of in light of this law if they didn't want defense attorneys would have to be mindful of when they're dealing with their clients. Even a fine at a filing level could be a bar. But I do think that this bill, based on the conversations we had last year in detail, this bill really does strike a balance on those who've been convicted of offenses. I'm not one to want to put any limitations on a lawful owner's ability to carry a gun who hasn't committed any crime, and I stand by that and I'll die by that. But when people have been convicted of domestic violence and they've had multiple bites at the apple, I just don't have much sympathy for them. These are the people I see who have really bad tempers and incidents of violence in their lives, and they happen over and over and over again. Just to be clear, this isn't the person who would have one bad day and get arrested and come before a police department and have to go into a system. That person's not going to get convicted of domestic violence. Even somebody who might have 2 bad days, a year apart, a couple of years apart, 5 years apart, they're not necessarily going to get convicted. This is the person. This bill was designed to focus on the individual who is a repeat offender and has brought on the ire of the court through a balancing test of the defense attorney and the prosecutor and the judge, either through trial or through a plea, conviction. And I think it's sound. I really do think it's sound. I'm always mindful of whatever Mr. Sakosha's comments are and what what his thoughts are. But I have to say, after everything I've heard, I really applaud the step in the right direction that this particular bill takes, because I don't have any sympathy for those who are convicted.
Senator Lombardi.
Perhaps I've had too much Diet Coke tonight. I've had 3 of them, so I can't shut up. But I can't concur with Senator Archibald Moore that we're at the precipice of perhaps a bill that actually strikes the compromise. And so I will ask, and I don't envision that there's going to be any action tonight, but I don't know that. But to the extent that there is not going to be any action tonight, I would ask the rhetorical question, not to the group here, but to Frank Sakosha, because he's not here in his defense, is I would want to know what, if any, issue the Second Amendment Coalition has with denying the right to have a gun for a person who is convicted of an offense that is a misdemeanor crime of violence that is not defined as a petty misdemeanor. And that's, if there is, I'd like to know, and because I'm as receptive as the next guy to gun rights folks, but this one here, if you're convicted of a non-petty misdemeanor of violence, domestic violence, is there an issue with the right to carry a gun at that point? That's the question that I would ask. And I'm not saying that rah-rah, Deb, I'm just saying that I think that this is the,
I aren't saying rah-rah, Deb.
Well, I'll be eager to hear it, but...
Any other senators have any comments before we listen to some witnesses?
Sure.
Mr. Bear, you done?
Yes.
Mr. Zania, you can proceed.